if I'm a company in distress, what are the major factors that I need to consider in terms of deciding which of these alternatives I'm going to pursue?
So I'll run through some of these bullets, the ones that strike my fancy here and now, and I'll elaborate on them. So let's go back to Bob's Burgers. That was a small burger chain, 3, 4 locations, let's say. All else being equal, I don't need to know anything more than just that to say, okay, we're really going to try to avoid an 11 or a traditional Chapter 11. Why? Because of the expense. Bottom line, the expense. And by the way, I said all else being equal, right? So that one data point doesn't just is not outcome determinative, but it absolutely is pretty relevant and causes a lawyer, at least me, to know immediately what subsequent questions I want to get into. It takes me into a particular path of questioning. So
and we're going to get into why it's expensive later, right?
Sure, if you'd like.
Yeah. Well, I mean, I think it's a little ironic, that here's a company that is, insolvent, and then one of the major options that it faces for how to restructure is a very expensive option, right? Which, we already know that it's having trouble with its finances. So
yeah, and years ago it wasn't the case, but certainly today, and certainly over the last couple of decades, it's become very expensive. Another thing that we will, at least the prepared slides tell us we'll get to, is the topic of subchapter 5 of Chapter 11, which is, it's a beautiful thing from the perspective of the small company that would like to file Chapter 11, but Chapter 11 is just too expensive. If your creditors are very loyal to you, if they like you as a customer, then doing some sort of restructuring is going to be easier than if not. Again, all else being equal, right? And if if you believe that they'll support your reasonable efforts, that may lend itself to an out of court situation. If depending on the size, so again, you have Bob's Burgers, but let's multiply, let's say, instead of being a 40 location chain, it's now a 400 location chain. And actually, I don't like burgers because there's no inventory. Let's switch that to Bob's Books. If Bob's Books has 4 locations and they're all in the same state, that's a very different situation than if it's 400 in many states. Right away, the process, what Chapter 11 does bring to the table, brings a lot of things to the table. But one of the things it brings to the table is it brings everybody in front of the same court. Because it's federal law overrides any inconsistent state or local laws. And a good example with the hypothetical Bob's Books is that, let's say the decision is to liquidate. Let's say everybody agrees, even the owners, that it's time to shut this business down. Let's just liquidate everything and get as much money back as we can get to creditors. Or perhaps let's liquidate 80% of the stores and be a leaner, machine, keeping the best stores open and rejiggering the business a little bit better. That can be accomplished through an Article 9, through an ABC, out of court, through bankruptcy. But once you get to the size, 400, 40 is a little bit in the middle. It's a gray area, but the larger you get, the more likely it is that the costs, the more expensive process that Chapter 11 is worth it, because Chapter 11 brings a lot of benefits. I'll give you just one example. if you remember Circuit City, Home Place, which was a furniture store once owned by Sears, Home Life, which used to be compete with Bed Bath and Beyond, um, Musicland, which used to own Sam Goody's and a bunch of other brands in all the malls. Those are all companies I was involved in. I was involved in each of their bankruptcies. And one attribute of each of their bankruptcies was that they all had these massive going out of business sales at locations that closed. And you may remember seeing people wearing, the streets, the sign walkers, advertising the GOB sales. Doing that under the protection of bankruptcy is way easier, because whether you realize it or not, there's thousands of municipal laws that govern going out of business sales, because in years gone by, companies, fly-by-night companies used to do them, and they were somewhat fraudulent to the public. So under the protection of the federal bankruptcy code, you don't have to really pay too much attention to any of those laws. I'm oversimplifying, of course, but that's kind of the bottom line. So just touching on on a few other bullets. If you're going to have a going concern sale versus a liquidation sale, that's a major factor that can help drive which way you're going to go, for a number of reasons. I'll give one example. Let's say that the exit strategy, the purpose of the filing is to effect a going concern sale from owner to buyer. And by the way, just to be clear, buyer could be a newco some of whose shareholders, or even all of whose shareholders, are the owners of Oldco. That's completely legitimate if done properly. So if the transaction is Oldco is going to sell all of its assets to Newco, then there are very good reasons to try to do that through a Chapter 11. And I'll stop saying all else being equal, because that's like a standard caveat. And for myriad reasons, but the most obvious reason. So if you're, a bankruptcy lawyer in the audience, which you shouldn't be, this is for journalists.
Get out of there, lawyers.
You're probably already a step ahead of my verbose words, because it's about free and clear on the sale. If I own a business, or I'm a private equity fund that owns a business, or whoever I am, the owner business, right? And it has lots of debt. And with the cooperation of, say, my senior secured lender, I want to sell all of the assets to Newco, which I also own. And let's say, I guess I'm find myself painting a hypothetical. Let's say all of the assets of the company are legitimately worth $50 million. And let's say the secured lender is owed $100 million. That means that unsecured creditors will get nothing. They're completely out of the money, because the senior secured lender, who has a lien on all assets, is only going to get paid 50 cents on the dollar. So that presents the sort of situation where owner of Oldco can sell assets to Newco, which he also owns. But to do that outside of the protection of bankruptcy is very risky comparatively to doing it inside of bankruptcy.